is Amy Bailey and I am an attorney here at Sivia Law, bringing you a video today on trademarks. Just a basic overview of what a trademark is, who might consider getting a trademark, and how you should go about choosing your trademark. When we look at the strength of your mark, we have a sliding scale that we use. It starts with the weakest, which is a generic mark, and it goes all the way up to the strongest, which is a fanciful mark. But in between, in that gray spectrum, is where we find the majority of the marks. Generic marks are typically not registrable. They involve words or phrases that are necessary to generally describe a thing. You can't trademark the word computer if other people need to use the word computer to sell their computers. You can't take the most generic word used to describe a type of good and trademark it. Next in line on the scale is what we call descriptive. Now, descriptive marks are somewhat self-explanatory, describing the goods or services that are being sold. And along the same lines of the generic marks, we don't like to register descriptive marks because the United States Patent and Trademark Office doesn't like to register descriptive marks because, again, they use words or phrases that the market needs in order to describe the goods or services that are being sold. You don't want to remove necessary words and trademark them and give only a certain person a monopoly on using that word. It would cause chaos. Next on the scale is suggestive marks, and suggestive marks are marks that with only a small little mental leap you can understand the play on words that might be occurring. So if we're looking at generic marks, an example might be just imported auto parts if you're trying to describe foreign auto parts. A descriptive mark might be the United Parcel Service for postal and shipping services. But a suggestive example might be sugar and spice for a bakery. The words sugar and spice are not directly necessary in order to describe a bakery, but there's definitely a connection between the mark chosen and the goods and services that are being sold. So next on the scale is arbitrary marks. Arbitrary marks are marks that are words in the English language that have a defined meaning, that are potentially widely used, and they're being used in a way that's not in line with what they are generally accepted to mean. So think of apple. Now, apple is a fruit, but Apple is also a brand of electronics. You have blizzard. Blizzard is a weather condition, but it's also the name of a video game company. So next on the line we have fanciful marks, and fanciful marks are the strongest marks in existence, and they are words that are made up by the trademark owner. If you're looking for examples, look no further than Exxon or Xerox. And Xerox might give you a clue there that that's a pretty generic name for an array of copying and printing devices. And once upon a time, the Xerox machine was at risk of being generic, which tells us right off the bat that your trademark is not necessarily registrable, not necessarily entitled to maintain its registration throughout the life of its use in commerce. So last on the list is fanciful marks. And fanciful marks are just made up words. So if you're looking for examples, look no further than Exxon or Xerox. These are not words that have any meaning in the English language aside from whatever they've developed or borrowed from their use as a trademark. Now, fanciful marks are the strongest marks because they are made up. There's no existing connotation for those words in the English language. And when we're looking at the strength of a mark, we consider what we call distinctiveness. As I discussed previously, the purpose of a trademark is to distinguish your goods from the goods of your competitors. And the way that we want to do that is by having a really distinctive mark. So when we look at that sliding scale, and again we have generic, descriptive, suggestive, arbitrary, and fanciful. Well, fanciful's the strongest, but it's not the only mark that has that inherently distinctive quality. In fact, suggestive, arbitrary, and fanciful marks are all considered inherently distinctive. And that's important, inherently distinctive. When you're going through the process of registering your trademark, whether or not it's suggestive or arbitrary or fanciful doesn't really mean anything. The only thing that we're looking at is whether or not your mark can be said to have inherent distinctiveness. And if it's suggestive, arbitrary, or fanciful, then it has that inherent distinctiveness necessary to get a trademark. But if your trademark is generic, it's probably not ever going to be registrable. But your mark might be registrable if it's descriptive, but that is dependent on whether or not your mark has acquired distinctiveness or has attained secondary meaning.